next episode of our CoP podcast, Empowering Minds and Protecting Lives. I'm here with my colleague Lydia Holland. I'm Gemma Garside, and today we're talking about whether a person who lacks capacity can get married. Hi Lydia.
Hi Gemma. If a relative is diagnosed with dementia, can they still get married?
Well, the issue of capacity to marry is one that has been considered by the Court of Protection in recent years, and the issue has been developed by the case law. The Court of Protection and Mental Capacity Act 2005 are governed by a principle of empowerment, so people are encouraged to make their own decisions without the imposition of the state where they can. Mental capacity is decision specific, and it's presumed to be present unless proven otherwise, even where a decision is considered to be an unwise one. A diagnosis of dementia, for example, then, doesn't mean that a person automatically lacks capacity, and the legal test for that specific decision must be applied.
So what's the legal test then, Gemma?
The test is that by virtue of an impairment or a disturbance in the functioning of the mind or brain, a person is unable to understand information relevant to the decision, retain that information, use and weigh that information, and communicate their decision. The court has established that the test for understanding the decision of entering into a marriage is that the person can demonstrate a basic understanding of the marriage duties and responsibilities, and they must also understand the reasonably foreseeable consequences of a marriage, including that the marriage would automatically revoke a previous will.
So what protection is in place?
Well, Lydia, there doesn't seem to be enough at the moment. Under the forced marriage legislation, it is a criminal offence to marry a person who lacks the mental capacity to consent to the marriage, whether they are pressured into it or not. But the conviction rate is very low. Guidance has been published for registrars to assist them in considering whether a party may or may not be able to consent to a marriage. There have now been campaigns to change the law, and the Law Commission is currently consulting on whether the law that a marriage automatically revokes a will should still exist.
What should a family member do then if they are concerned about their relative?
Both parties to a marriage must give notice at the local registry office at least 28 days before the wedding ceremony, and these are published, so family members at the moment, all they can really do is be alert and check at their local office if they have concerns. If they see that their relative has placed a notice, then they can file an objection with the registry office, and this is also known as a caveat. They will then determine whether the marriage can legally proceed, and it may result in proceedings in the Court of Protection.
So in that case, is it possible for a person who lacks capacity to divorce?
Well, quite simply, yes. However, the court will require the party lacking capacity to have a litigation friend. This is somebody that's appointed to represent them and act in their best interest in the proceedings. This can be a family member or close friend, but if there's nobody suitable or willing to act, then the official solicitor can be appointed.